This is where sometimes the prosecution of these COVID tickets is very puzzling to me because, while the prospect of pastors not being punished for holding worship services in BC was so significant to the Crown in BC that they have spent significant resources and time fighting to ensure that these pastors are punished. In that same time period, many, many, many criminal offenses have been dropped because the Crown doesn't have the time to prosecute them and they can't find court time.
Welcome to the 10th episode in the second season of Justice Center Weekly, a podcast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with us today is lawyer Marty Moore.
Hi, Kevin.
Today, the topic is the Jordan application. What are they, and why, and for what are they used? Specifically, Marty will tell us about a Jordan application that's been recently filed in a Justice Center case in British Columbia. He'll give us the context, describe the case, and then maybe we'll dive a little deeper into the history of the Jordan application. So, Marty, why don't you start us off by telling us the facts of the case?
Well, Kevin, we've actually talked about these cases before. This is the prosecution of pastors in BC for having the audacity to hold church services in times of deemed COVID pandemic. And of course, BC, as your listeners will know, prohibited any in-person gathering for worship. And that includes outdoor gatherings, indoor gatherings. You couldn't gather with two people outdoors to celebrate religious worship service in BC for about 6 months from 2020 into 2021. And so these pastors did that. They were charged for doing that. There's been a lot of constitutional litigation, but they're still being prosecuted now, 30 some months later after they were charged. And so you asked the question about a Jordan application. Well, that is an application where a defendant seeks to assert their right under the Canadian Charter of Rights and Freedoms in a Section 11B not to be tried in an unreasonable time period. In other words, you have a right under the Charter to be tried within a reasonable time. And so a Jordan application is an application where you say to the court, look, this case has been dragging on for such a long time, it violates my charter right to a speedy trial, essentially, to be tried within a reasonable time.
I actually thought these cases were concluded. I guess I am surprised that you're filing then a Jordan application in them because they're still ongoing. Why is it taking so long? Or do you have is that spelled out in the Jordan application?
Yeah, well, the question of why it's taking so long, in this particular case, it's interesting. What happened is everyone agreed that the main issue in this case was not so much whether or not these pastors in fact held worship services, which is what a trial is for. The main issue was whether the constitutionality of the public health officer's order to prohibit worship services, whether that was something the courts would uphold. And so, of course, these pastors, many of them actually sought to preemptively challenge those orders before they were charged. And when they did get charged, they also raised the constitutional issue. And so what happened is the Crown decided to file what's called a vukelage application against their raising of the constitutional rights. They said you have no right to raise the constitutional issue in BC because you had to write to Dr. Henry and get an exemption. Well, some of the pastors said, we did, and she didn't respond. Another said, we did, and she gave us an exemption that didn't apply to us, and in any way it was unfair, and it was used for improper purposes. That's what they claim. And so that issue went to court. And it was going to go to court, I should say. There was, some briefing and all those things. It was scheduled to go to court. The charges were laid in 2020 and then in 2021. This matter was scheduled to go to court in January of 2022. Well, what happened in January of 2022? Well, in January of 2022, the British Columbia Provincial Court was ordered by the Chief Judge of the British Columbia Provincial Court to shut down court operations. And so, everything had to go virtually. So as, many of us have become more familiar with as lawyers, you can actually attend court by a virtual appearance. And so we wrote to the court and we wrote to the Crown and said, look, we would be happy to attend in person. We have no objection to that. We don't see a need for a virtual hearing. In fact, we would prefer an in-person hearing. That said, should the court require, we will attend at this hearing in person. We will attend at this hearing virtually. Everyone seemed to be on the same page with that, but then something was interestingly noted. In all of the zeal of, the powers that be to restrict people's in-person gathering. Now, this is late, and this is 2022 now. We're not 2020 anymore. We're not 2021. We're quite a ways into the COVID era here. Everybody knew what was going on. And how COVID would affect and potentially affect court processes when they shut things down, for example. But before the hearing was to proceed, the Crown said to the judge, we don't think you can actually hear this matter by a video live streamed argument because the regulations that allow for video appearances at court may not allow for these COVID matters to be heard, which is an interesting and a little bit ironic. You shut down the court system for in-person attendance because of COVID. You make a bunch of regulations saying all sorts of things can be heard virtually, the government does, but you don't allow COVID matters to be heard virtually. So if you charge someone for violating a COVID matter, they have to appear in person, even though they're charged for gathering in person. Just an interesting and somewhat ironic twist. And so what happened is, while this matter was supposed to be heard and argued, this particular part of the prosecution of these pastors was supposed to be heard and argued in January of 2022, because the government of British Columbia, the court system, had not had the foresight to add the prosecution of COVID matters to the allowance for virtual appearances. That pushed this matter off into August of 2022 before anything would happen. No court hearing could happen. So it delayed the matter an additional 9 months. And then halfway through that delay period, the Crown decided that they wanted to change course. Now, instead of actually arguing about the constitutional issues in the case, the Crown decided that no, we actually want to argue about whether or not these pastors held worship services. And so we said, we don't think that's the right idea. There's, you've issued dozens of these tickets. Let's just deal with the main common issue and then that'll solve a lot of the problems. No, we just want to start proceeding to the trial of whether or not these pastors are in fact guilty of violating the public health order. So after many case conferences and different things, the Crown's argument was accepted by the judge, and the dates on which the constitutional issues were supposed to be argued in August of 2022, those dates were now set for a trial about whether or not one particular pastor held one particular worship service on one particular day and whether or not those actions violated the public health order. There was a lot of questions at that trial, as one could imagine. Questions such as, is a worship service a support group? Because you could meet at a support group in person, but you couldn't meet at a worship service. So, is the fact that we mentioned God at this event not a support group? Because clearly people are being supported. There's evidence about people being supported and uplifted and encouraged and those kinds of things at these worship services. There's a debate about that. There's a debate about, why would you charge the pastor of a church when he's just the employee of the church? And in fact, it's the church board that's made the decision to hold the worship service. So there's a number of issues to clarify at whether or not the charge was appropriate, whether or not the facts were in fact met. All that to be said, this one pastor on one particular date was in fact found to have violated the public health order by preaching at a worship service. So that issue was done. But by the time those issues were dealt with, the 4 days of court time was used up, and now they wanted to schedule the constitutional issue, on which many other charges were pending. To get court time, they now went all the way into 2023. March of 2023, in fact. And that is when the constitutional issue was finally argued and then decided. All of this to say, Kevin, we are now not in 2020. We're not in 2021. We're not in 2022. We are now in 2023. And only now are most of these pastors actually getting their day in court on whether or not they, in fact, violated a public health order in 2020. And so this is what is viewed as an unreasonable delay. And when the name Jordan comes up, it's actually a reference to a Supreme Court case which actually set clear standards on which judges are supposed to rule. Their timeline for a trial in the provincial courts in Canada, which is where these COVID tickets and most, traffic tickets and minor offenses are charged and tried. The timeline for charges in provincial court, if it's longer than 18 months, well, that is viewed as an unreasonable delay, and then the court must dismiss those charges. That is what the Jordan rule says. And if it's a serious charge, say murder, something along those lines, which is tried in the superior court levels, that would be the courts of King's Bench or BC Supreme Court or Ontario Superior Court, etc. Well, in those cases, it's 30 months. And what we have in these circumstances is pastors not being given a court date, not for 18 months, but for 33 months. And so that even exceeds the allowable delay for serious offense. And of course, these are, I don't think they should be offenses at all, but even under the categorization, they're viewed as minor offenses and essentially a regulatory issue, not a criminal issue either. And so that is the crux of the matter. Is the Crown made some choices to, well, let's deal with the constitutional issues. We agreed with that, and then the government shut down the court system when they completely had the ability to allow for matters to go through virtually. Well, they didn't allow for COVID matters to go through virtually for absolutely no reason. Just, happened to, whether it is lack of paying attention. They seem to be quite daft at restricting everybody else's rights and freedoms and making sure that you couldn't do a single thing outside of their control. But in their own processes, it seemed that the government was lacking in some insight. They had lots of insight into your life, but not a lot of insight into their own lives. That's not a good thing for the government there. So, and then midway through the next segment of delay, the Crown decided to change horses and not even deal with the constitutional issue. So rather than a constitutional issue being decided in the January 2022 timeframe, it didn't get decided until about March or May of 2023. And so extensive delays there. The government, and we did a hearing in this on this issue last week in Abbotsford, couple-day hearing, and the government's argument, well, it's COVID delay. It's COVID delay. Well, it's not quite COVID delay, Kevin. When the government says everything else can go virtual, but your argument can't go virtual, and we are saying we will consent to going virtual, well, that's on the government, and the government can't delay your hearing and get away with it. That's the Supreme Court says, look, we have to set some standards here, or we'll just have people facing prosecution for indefinite and indeterminate periods of time. And so at a couple-day hearing in Abbotsford, a decision is expected to be released here in June, and if it's favorable, we can expect to see a number of charges against churches and pastors in BC dismissed by the courts for violating Section 11B of the Canadian Charter of Rights and Freedoms.
Okay, but on these delays, they have to be all on the side of the government. Is that correct? Like, I know that there are instances where, defense will request a delay or cause a delay. That doesn't get counted into the 18 or 30 months, does it?
You're right. Yeah. Any defense delay. So if you can attribute the delay to a defense counsel motion, which is illegitimate with actions where they're just not making themselves available, well, then that delay is not counted. At this point, the Crown would have to somehow come up with more than 20 months in some cases of delay from the defense counsel to justify the actions or justify the late time that these matters got to trial. Which would
On
be
the Jordan
a very
application, then I
period of
understand.
time.
Oh, sorry, go ahead. Can you
That
hear
would
me?
be very difficult for the Crown to justify.
Okay. On these applications, the Jordan applications, now I understand that the whole notion of having the right to a speedy trial has been around for, I don't know, a couple centuries. Why did it take so long for us to codify it and come up with some timelines? That's what I'm very curious about. I agree with the timelines. I know that these delays caused by, the judicial system, whether it's the lack of judges or just plain scheduling problems, they've been around a long time. And why is it we've only come up with this concept of a Jordan application so recently? I guess that's the curious question. I don't know whether you can answer it.
Well, then the name Jordan comes from the case, and I believe it's a case within the last 10 years from the Supreme Court of Canada. So that's why you're only hearing about Jordan applications recently. But the concept of unreasonable delay, of course, has existed under Section 11B of the Charter since 1982. And you're also correct to know that the view of not being tried within a reasonable period of time, that has been a concern for defense lawyers and for people being prosecuted for a very long time. It's a fundamental principle of justice that you're tried within a reasonable time. You cannot be languishing under charges of criminal conduct, for example, without having your right to a day in court indefinitely. And so it's certainly building on that history where our charter said, look, you have the right to be tried within a reasonable period of time. And then to avoid a lot of confusion and finger pointing, the Supreme Court said, look, if this matter has been delayed through the court system or through the actions of the Crown for more than 18 months and it's a smaller matter, or if it's more than 30 months and it's a significant type of criminal matter, well then that is simply unreasonable delay and we will not countenance a conviction under those circumstances. And the court is then in those cases under an obligation to direct a stay of the prosecution.
Okay, so in this current case, then their only defense really is that we had a COVID delay and that wasn't our fault. That wasn't the court system's fault, even though, as you described it, it sounded like their fault. Is that their only defense, or do they have other defenses?
Well, leave it to government lawyers to come up with all sorts of creative ways to spin things. They have a 48-page brief, Kevin, on this particular matter. So they have numerous different ways that they're trying to slice and dice things. It was encouraging in court, however, to see the judge trying to say, well, you are trying to now attribute all sorts of delay to defense, but what actual delay was caused? And there were some admission that was very difficult for them to actually claim defense delay in some circumstances, but they definitely tried, Kevin.
And of course, you're looking fairly confident there. I assume that those delays won't stick. So it sounds like you're confident.
Well, we won't predict judicial decisions. That would be a bad betting game these days, but it's an important issue. It's an important circumstance. And we see this issue actually arising in other prosecutions across the country, Kevin. We have seen, for example, numerous clients that we have facing ArriveCan charges, facing even quarantine and other Quarantine Act charges and other COVID charges, having their matters dismissed when our lawyers write to the prosecutors and say, look, this matter didn't get brought to a hearing for 30 months, for 3 years in some cases. You want to bring it now, and it's, your rule is 18 months. We think you should reconsider, or we'll have to file a Jordan application against this prosecution. And you know what? In many of those cases, Kevin, we have seen the prosecutors do the right thing, in my view, dropped these prosecutions, which in my view were never in the public interest at all. As you know, prosecutors have the role of determining whether or not the prosecution is within the public interest, the prosecution of a particular charge, and whether or not they have a reasonable prospect of success. And once you factor the Jordan application in to say, well, the delay has been there for a long time, and you factor in the public interest, which I say the public interest on prosecuting a violation of a public health order that you have no evidence that caused any harm at all. Well, you have no evidence that the public health order did any good in most of these circumstances. Well, what's the public interest? And giving them a reason under Jordan to say, well, what's the likelihood of success on that, given the late time frame? We've seen numerous charges dropped, Kevin, and so that's been very encouraging to see as well.
Well, we have on this show and the other podcast from the Justice Center talked about the delays in the justice system, and a lot of the times, at least if you look at the stories about this, it's attributed to the lack of judges. But that doesn't sound like this was a problem here at all. Sounds more like scheduling and the shift in tactics by the Crown. Is that what's happening in other cases that you've experienced? Is it the actual lack of judges to schedule into hearings?
Well, I think it's a bit of both here, and you're right. I do believe that there is a significant shortage of judicial availability in most, if not all, jurisdictions in Canada. Once a judge is what's called seized of a particular matter, that matter and the motions in that matter, the hearing in that matter, the trial of that matter will proceed before that particular judge. And so, for example, when you're looking at a 2 or 3 or 4 day hearing before a particular judge, and that judge has other matters that they are seized with, finding that availability with the judge, in this particular case in BC that we've been talking about, that would take 6 to 9 months to find that availability. And so that's a factor of these judges being, significantly busy, being, one of not enough judges sitting on the bench. And of course, Crown action has to proceed in light of that. This is where sometimes the prosecution of these COVID tickets is very puzzling to me, because while the prospect of pastors not being punished for holding worship services in BC was so significant to the Crown in BC that they have spent significant resources and time fighting to ensure that these pastors are punished. In that same time period, many, many, many criminal offenses have been dropped because the Crown doesn't have the time to prosecute them and they can't find court time. And so that is, it kind of is a light into a very dicey decision, in my view, that's been made by many jurisdictions to prioritize the prosecution of alleged COVID rule violators over the prosecution of actual criminals. And that should have consequences, especially when those decisions result in delay to our clients. And you recognize that they've made decisions to drop other charges so that they can prosecute pastors. You know what? It would be just all right with me if they find that the court says, well, you took too long even in prosecuting the pastors that you prioritized.
I see, yeah. I actually want to just get into the weeds a little bit, because there's lots of mysteries about the court system that you as a lawyer know, and I have no clue. I've learned a lot, doing these interviews for the Justice Center on these podcasts. But one of the things in the allocation of judge time that came up on several cases was this idea of case management. And I'm wondering if the case management, it sounds like, we're supposed to manage the case so that it gets to court and everything happens on time. Is that where things go wrong? And I know that certain judges are assigned to manage cases, but they're not the judges hearing the cases. Is there problems there as well? Maybe just a moment or two on case management. Is this causing problems?
Right. Well, case management is where the lawyers meet with the judge to discuss the litigation schedule, the timing of the different motions, the hearings, and the exchange of evidence, etc. Case management is an essential role in many cases to make sure that it is facilitated in a timely fashion. It is the obligation of all parties to see that matters are conducted in a timely fashion. Defense counsel have an obligation in that. Crown prosecutors have an obligation in that. The court system and the judge at the case management hearing has an obligation to do that. And so these case management processes are where the parties put their positions on the table. In the case that we're talking about, presently, we saw that, the Crown was proceeding in one direction. They said, we will prioritize the determination of the constitutional issues which are common to everyone, and we agreed with that, and we thought that was the right way to go. And then, midway through, in case management events, which, sometimes called pretrial conferences, they switched their position. And so, then it was up to the judge to determine whether or not the judge would allow the lawyers, the Crown in this case, to switch their position. Now, matters in courts in Canada are generally party-driven. In other civil law jurisdictions, say France or maybe even Quebec, you might see a judge become more of a investigator, almost a prosecutor, a fact, calling their own evidence, asking their own questions. But in the common law system, the view is that you would have a prosecutor and you'd have a defense lawyer, and then those two parties really lead and direct the case. So, you can't expect case management judges to try and put their own thumb on the scale. When I do see case management judges really getting really involved in things, sometimes that's not as good of an idea, because in the 30 minutes that they have to be involved in the case versus the dozens of hours the lawyers have put into the case, they may not see all of the issues in the same way that the lawyers involved actually see them. But there is an obligation through case management to move matters forward in an efficient way, but in a way that doesn't compromise the integrity of the system and the rights of the accused.
Okay, well, that was going to lead to my next question, which is, the role of the judge in case management, because, to me, it sounds like there's a lot of sort of perfunctory stuff going on here. And I know that a lot of questioning of witnesses happens, in interview, not before a judge, and affidavits are sworn and that kind of thing. Is a judge necessary in the case management? And is that something where, you could appoint others to do it, or is the role of the judge completely necessary in the case management phase?
I think the solution is not to limit the role of judges. It's probably to expand the number of judges that we have and allow them to be more able to have the time to focus on the important issues that are before them. I was just in court, actually via virtual appearance. One of our lawyers was present in the courtroom in New Brunswick, where there's a very large constitutional case occurring. Many parties from all over the country are there, and there's a lot of case management that has to be done in that particular case. It's already been dragging on for a long time, and it's very important that a court get involved, because a court can make orders. All the other parties can try to make agreements, but a court can make orders. They can say to a particular lawyer, you come back on this particular date with this evidence, this information, and that's how we're going to move things forward. And failure to comply with court orders jeopardizes your position in the litigation itself. And so it is important that you have empowered court officers there at case management in many cases, and these hearings actually do often result in court orders. When the parties don't agree on a particular path, the court makes an order in those cases, sometimes a fiat, sometimes an actual order outlining the process. And so, I think it wouldn't be something that you would be delegating off to others. There are, for example, in different court processes, whether it's a federal court, it used to be called prothonotariys, now called, I think, some sort of a judge, but essentially a lesser judge that has the ability to issue court orders on lesser contested matters, maybe not on the constitutional merits of a question, but they do have the ability to issue orders, scheduling orders. You have things like masters in superior court levels that issue decisions, actually, that don't necessarily have the same status as a judge, but they have the ability to issue court orders. So that issue of, do you have to have the top dog, whether it's a provincial court judge or, superior court judge, do you have to have them ruling on everything? That has been addressed in some ways in some courts, but you certainly have to have someone involved in the process that can make orders where the parties can't agree.
So in case management, you need authority there, is what you're saying. So yeah, it's
You absolutely do.
something
Yeah.
yeah. Now, does case management delay the process? Is that where the delays occur, or is it in scheduling the actual trial? Where would you say the majority of the delays occur?
The majority of the delays are almost always delay in court time. So, for example, where it's not a prosecution, where it's a civil case, for example, at the Alberta Court of King's Bench, you file an application in 2023, you brief it all up, it's all ready to be argued, and you get court time in 2025. Over a year and a half out. And so that is, you just, it's the fact is they'd have no available judge to sit for a day to listen to that case for that time period. That is the extent of the delay in the superior courts. And provincial courts, sometimes they're a little bit faster, but still 6 to 9 months for a hearing time before a particular judge is a significant problem. I wouldn't say the case management is a cause of delay. It's often you're attempting to actually speed things up. Case management is not there to hold things down. It's actually just there to facilitate a timeline and an agreement of the parties, ideally.
Good. Okay. Well, I guess we can sum up by saying thank heavens for the Jordan application, the hard limits that they've set on getting these trials to court. Okay, Marty, thanks a lot for bringing us up to date on that particular case and giving us a little bit of the history and the background of the court system and the Jordan application. I hope to speak to you again real soon.
You're welcome, Kevin. Thanks. I look forward to it.